Moving on, a government-appointed panel has called for preemptive regulations on big tech companies to curb their dominant behavior. The committee, which was appointed by Corporate Affairs Ministry last year, has warned that addressing anti-competitive practices after they occur could allow companies to evade scrutiny. The committee has also proposed monetary penalties of up to 10% of global turnover for companies identified as systematically significant digital enterprises. Shivani Bajaj joins us now for more on this. Shivani, take us through the key recommendations from the panel.
Well, the much-awaited report by the Committee on Digital Competition Law, which is the CDCL, has finally been submitted to the Finance Minister. The committee, which was formulated last year under the Ministry of Corporate Affairs, has suggested to form a separate digital competition law with ex-ante regulatory strategy specifically tailored for large digital enterprises. Remember, ex-ante regulations are rules or laws established beforehand to prevent potential issues or problems from arising, rather than addressing them after they occur. So the proposed ex-ante regulation is aimed at ensuring proactive monitoring of these big tech enterprises, empowering the Competition Commission of India to intervene preemptively. Let's first understand why this law is necessary. So the report highlights widespread concerns regarding the dominant behavior of large digital services providers, which leverage data network, assets and economies of scale. It emphasizes the necessity of a new ex-ante regulation to level the playing field for smaller players in the digital markets. This call for regulation arises amid ongoing conflicts between big tech firms like Google and smaller Indian companies. Currently, the Competition Commission of India operates on an ex-post framework, meaning actions are taken after the anti-competitive practice occurs. However, the report suggests that this approach may not be suitable for the digital markets due to its time-consuming nature. The committee warns that relying on ex-post demonstration of dominance could allow large digital enterprises to evade timely scrutiny. Now, the committee suggests that designating systematically significant digital enterprises, also called the SSDEs, based on specific criteria, ensuring only major tech companies in core digital services face these regulations. It also proposes that if multiple companies in a group offer digital services, they should all be considered as ADEs. This could happen in two ways. Now, either the main company is labeled as the SSDE and others as associate digital enterprises, or a different company directly involved becomes the SSDE, with its parent or other group entities becoming the ADEs. Now, the report says that the CCI should have the flexibility to decide which company gets what designation. To enforce the compliance with these ex-ante obligations, the committee proposes monetary penalty of up to 10% of the global turnover of SSDEs, along with additional penalties for incorrect reporting and vicarious liability of key managerial persons. Furthermore, if the SSDE is a part of a group of companies, the committee suggests that the maximum penalty should be based on the total global turnover of the entire group. The committee also recommends that the exact amount of penalty should be decided by the CCI.
Right. Thank you, Shivani, for that update. Moving on, the State Bank of India